Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Today is June 7th, 2018. This is our bi-weekly community conference call where we try to answer community members' questions. This does not form a attorney-client relationship as you would have heard when you logged in. There is a recording that announces what the purpose of this call is. Now that said, I'm going to begin. There's only one frequently asked question that I saw today. There are others, one or two, but I don't think they need to be dealt with again. We've already dealt with them several times. This was from two different folks, and the idea was, as many of you know, that there have been predictions that EB3 category, at least temporarily, may advance faster than EB2. So the question is, if I have an approved EB2 I-140, can I file a 485 under EB3? Or can I refile the I-140 under EB3? What would be the right thing to do in these circumstances? This is a difficult question to answer because even though there is a very attractive option that we've got an EB3 date that's current, we can file the 485, we get the EAD, spouse gets the EAD, and we have the huge benefit of AC-21 portability to change jobs or even to start our own business and work for our own company. But we don't know the movement of the EB3 cases. How fast are they going to move eventually? I would recommend, if you want to consider this path, in my view, the safest option is to get an I-140 approved under both categories, EB3 and EB2. In my view, that's perfectly legal. We've done this in the past. There have been situations like this that occurred prior to this one. So if you have an EB3 case approved already, I'm sorry, let me rephrase that. If you have an EB2 case approved already, file another I-140 requesting EB3, and if the priority date becomes current, just file the 485 when the EB3 request is still pending. Now, if you have both EB3 and EB2 approved, you can file the 485 with the EB3 case as and when the dates become current. And later on, if the EB2 is moving faster, technically, the government will give you the benefit of whichever is quicker for you. So once again, let me summarize. If you have both EB3 and EB2 approvals already, great, good for you. You can use either one. If you have an EB2 approval and you want to take advantage of the EB3 upsurge in the priority dates, file for an EB3 I-140 with a copy of the same POM application. You can do that. If the I-140 is approved quickly, great. If not, and the dates become current, while the I-140 is still pending with the receipt, you can file an I-485. So you'll have an EB3 pending with an I-485 coming along. Now, if tomorrow the dates become better moving for EB2, because you have both I-140s in the works, one approved, one pending, or maybe both approved by that time, government will automatically give you the benefit of whichever category is moving the fastest. That's the way I think it will work. And that's the way we've seen it work in the past in our own office when dates became kind of staggered like that. Now, Kumar Sena had some other questions. Let's see. One of the questions here was, can we port down to EB3 if we have an EB2 approval? Whew. You know, the question is, this is an interesting question. I'm not sure I have a good answer for it. The question is, if I have an EB2 I-140 approved, can I file under the EB3 category? I think no. I think you will need an I-140 approval. Of course, I would need to verify this. I haven't had to so far, but that would be my guess. Next question is, from Kumar, I'm currently holding I-140 and EB2 with priority date of 2009. I'm planning to file a new I-140 with the same perm in premium processing. Right, you heard my earlier discussion, Kumar. So you can definitely file an EB3 with the same perm and even file a 485 when the EB3 is still pending. And if the EB3 for some reason tanks, the EB2 I-140 shouldn't have any problems. That's already approved. I don't see a better approach possible, Kumar. Okay. If anyone has a follow-up question on this, press *5, please. Any follow-up questions on this? Press *5 on your phone. Okay, let's get started from the beginning. This was the only frequently asked question I saw. Let's see. The first one is from Pravan. Wife is currently on H4EAD. Employer filed for 2019 fiscal year cap H1B consular processing. She's got her receipt. We're planning to go to India May next year. Okay, so the question is, if her H1B is approved consular processing, we are in India, can she return with H4? The only problem is, as far as I know, Pravan, I think they are wrong in this conclusion, but government concludes unless you receive a change of status or a visa stamping for consular processing on H1, you are not exempt from the quota. That's the problem. *5 if you have a follow-up question. *5. So for her to be exempt, she would have to get a visa stamping. Let's see. We have a question from, I guess, Maryland. Okay. Yeah, Maryland, go ahead, please. Maryland.
Hello, I had one follow-up question.
Yes, sir.
Yeah, so regarding this quota thing, so if the person has an I-140 approved in EB2 category and his 6 years are over, and let's say he has to go to India for 2 to 3 years for some family reason, and he wants to come back. So if the 6 years are over and he's in India, so can he use his I-140 to file extension with any company or the company with which he has the I-140 approved without coming into the quota?
Yes.
Okay, so if we have I-140 approved, then it doesn't matter if the 6 years are over, we will still not come under quota. We can file for direct extension without coming under quota.
You will, as long as your H1 period was within the last 6 years. I think with the I-140, this is a little bit of a gray area. You would be able to be exempt from the quota even past the 6 years of approval. But if it is within the last 6 years, you definitely are not subject to the quota.
So when you say the H1B approval within the last 6 years, does that mean the last H1B extension? Like means in the past around 6 years, I have taken my H1 extension.
Let me explain. Even though you're asking me a question off topic, I'll indulge you. This is the way it works. 1 second. This is the way it works. So far, this interpretation could change. Let's say that your H1 has been approved from 2014 through 2017. Okay. So the question is, which 6 years are you looking at? Is it 6 years all the way to 2014 when it was approved, or to 2017 till which it was approved? And the answer is right now it is till 2017. So if you have an H1 approved from 2014 through 2017, currently government thinks you're okay till 2023. You're not subject to the quota. Personally, I think when you have an I-140 approval, you are not subject to the quota even past 6 years. I think, but I'm not sure because the regulations get kind of murky around there. So definitely so far up to 2023. Even if government were to change its mind, they couldn't take you beyond 2020 because that's in the statute. The statute says you will not be counted towards the quota if your H1 was approved within the last 6 years. So even if they went back to the date of the approval, they could go from 2014 to 2020 instead of 2017 to 2023. In either case, last 6 years from the date of the approval are safe.
So my current H1B extension approval, which I got is last year in May, I think April or May 2017, and I got till May 2020. So this approval, so if we start from May 2017, so I can use my I-140 in India to get the extension without quota up till 2023?
That is
May
correct.
2023?
That is correct. Yes, sir. Okay. I got to move along. I took you out of turn. I got to move along. Okay. Good luck.
I'm sorry. Yeah.
No worries. Bye. Okay. So I like to maintain a discipline here, guys. So that's the reason. Okay. We have another. All right. This gentleman was one of the first callers. So let's take his call. Let's see. This is from Kansas. Is it from Kansas? Yes, Kansas. Okay. Yeah, Kansas, go ahead, please.
Hey, I'm Pravan's wife. So you were saying I should be getting H-1B visa stamping?
Right. Ma'am, the problem is, the last time I checked on this issue, which was a few months ago, government was of the opinion that even if the H-1B is approved, if it is approved consular processing, you are not exempt from the quota until you go get H-1B visa stamp.
Okay.
Okay?
Okay.
Good luck.
Okay, sounds good. Thank you.
You're welcome. Okay, so next question is, so there's a whole series of questions about somebody forgot to mention a traffic violation, which is a civil violation on driving record, and she had pled guilty and paid a fine of $82. It was a moving violation. Is this a problem because in the DS-230 she had said, no, I've never convicted, I've been never convicted, charge, offense, crime? And see, it depends upon the question, the exact question. I don't think it's a problem for your green card. As to your naturalization, just read the question carefully, answer it accurately. I don't remember what the exact question is, because this is not an arrest usually when you are stopped for a traffic violation. And I think the naturalization question specifically exempts traffic violations, but you can double check that. So it depends upon the question. One thing I know for sure is that before they give you a green card, they run an FBI check on you, and that ticket would have showed up in the FBI check. The fact that they approved your green card should rest your mind that it's not going to be a problem for your green card. Okay, so I would look, if you were filling out the N400 and you had a doubt about the question, just answer yes and attach an explanation. I personally don't think it's going to be any issue for you. Yeah, so the safest thing to do is answer the question accurately. If the question is wide enough to cover a traffic stop, put that in there. Say, yes, she was stopped back in XYZ year, and that should be the end of the story. Okay? *5 if you have a follow-up question. I don't think this is a serious issue, frankly. Next one is Kamesh Reddy. I-140 processing is in progress. Employer might be filing it in early or mid-June. I've got my current H-1B valid till June 30th. Based on the time spent outside, I have 27 more days to reclaim. Okay, which is July 27th. So is there a reason you wouldn't file I-140 premium processing? Because that could hurry things along? Okay. Should I apply for extension to reclaim 27 days now? Well, I don't think this is an easy question to answer, because once you file it, I think you will have to file a second case for a second extension when the first case is pending. Personally, what makes sense to me is an I-140 premium processing. You typically have about 10 days to leave the USA once your status expires on the H-1B side. Okay. *5 if you have a follow-up question. I see there's one hand raised and I'm not sure what this is in reference to. *5 if you have a follow-up question. I won't do new questions right now, guys. If your question is new, please put your hand down. I won't answer it. If it's a follow-up question, I'll be happy to answer it. So let's begin in the order that you logged in. This is Maryland, same phone number. Okay. Maryland, go ahead, please.
Yeah, so this is a follow-up question regarding to this question only. So, as you said that we have, when our status expires, we have only 10 days to leave US. So, sometimes what happens is that when companies file H1B extension, they file when your expiration date is closed, and by the time the denial or result comes of the petition, your status has already expired. So let's say recently one of my friends H1B extension got denied and his status was already expired. So now when he will go to India, will he be considered as overstaying or not?
No. What happens is, as long as you have a timely filed application for extension or change of status. I have actually a fairly lengthy discussion on this a couple of months ago. I think we did that. You can check the frequently asked questions, where I discussed the difference between being out of status, in status, authorized period of stay, and unlawfully present. I would just say this for today's discussion, that as long as a timely filed application is pending, if the application was made in good faith, honest intentions, you are legal to stay in the United States until the case is denied. And if you leave within a reasonable period of time from that, you are not really considered to have damaged your status in any major way. So if you leave USA and you were here a week or 10 days extra, you have to reveal that yes, you were present in USA out of status unlawfully, but unlawful stay of less than 180 days doesn't hurt you, and the fact that you left in a reasonable period of time should be accommodated by the consulate. It's not a big deal at all. Okay?
Okay.
Good luck. Okay, let's see. Now we have another question from Minnesota. Okay, Minnesota, go ahead. You have a follow-up?
Hey, hi, sir. This is Kamesh Reddy. I have posted this question.
Ji, Kamesh.
So my I-140 is filed in premium, sir. It got filed on May 30th.
Okay.
After I posted this question.
Okay, good.
So it got filed in premium on May 30th.
Good.
Yes, and I was talking to my attorney, or I was consulting my attorney last week after the I-140 was filed in premium, and he was saying we might need 3 weeks for sure to get the approved I-140 document on hand if there is no RFE for the case. And only after that they can file the extension beyond the maximum date, which is like July 27. But so I asked them for advice around what to do now, wait for the I-140 to approve and then file an extension, or
hang on.
Or file an extension now.
Let me jump in here for a moment. This is what I would do if I were your lawyer. I would get the LCA approved, get the package ready to file. If I don't get the I-140 approval in hand by the time I have to file the H-1B, I would file with an approval screenshot or approval receipt. If I don't have an approval, I would file for 27 days. Okay. While it is pending, if I get another approval, I would use the same LCA or even get another LCA approved and file for an extension while the first case is still pending.
Okay. And they don't have to withdraw the previous extension request?
They do not.
Can they file an amendment on top of it?
It's not an amendment. It's an extension on top of an extension.
Oh, okay. Okay. So that has to be treated as a separate extension. So the first one has to get approved as well as the second one also has to get approved.
It forms a daisy chain. Yes, that's the way it should be. And I don't think that's a problem at all procedurally.
Okay, yeah, exactly. That is what my attorney said, saying they'll keep everything ready, wait until June 27th kind-ish, and then if we don't get the I-140 approved by then we will file with your 27 days reclaim thing, and then after we get the approval, we probably have to see how do we do the AC-21 extension. But I was also told that I have to leave the country before 15 days of my max out date. So I was not sure why I have to do that.
No, that's 10 days, not 15. And I personally think that your I-140 should be adjudicated by that time. But if it is not, then I would do the same thing, what your lawyer said. Leave within 10 days after the 27-day count, even if the case is pending. Come back after the I-140 is approved, another extension is approved.
So the 10 days, is it required for the 6-year beyond extension? Is that why we are asked to leave before 10 days?
There is a new regulation that adds 10-day period to your legal status. You're not allowed to work, but after your H1 expires, you have to leave within 10 days thereafter.
Okay, no. What they were asking me to do is July 27th is my max out date. They were asking me to leave by July 13th per se, so that there is 2 weeks. Yeah.
Okay.
They were telling that
I was with your lawyers, very happy with their advice until you came to this point. Now it doesn't make any sense anymore.
Yeah, I was not getting why I had to do that, and they were saying we need that 10-day period as an excuse to file extension beyond 6 years. If you're completely maxed out, there is no days left. You cannot do the extension beyond 6 years.
These lawyers have not read the law since the year 2005, when the law was changed that you don't need to be in H1 status to get an extension of an H1 status.
Oh, okay. So it doesn't really matter.
That law changed on January 1st, 2005. Before January 1st, 2005, the law was if you wanted an extension, you had to be in H1. That is no longer the law.
Okay. So I can still be there till July 27th, per se, if my decision is still pending, and I have to leave by July 27th to be
and you can leave, and they can still file an extension of the H1B. You are outside USA, you don't have H1 anymore, but that's okay. It doesn't require the law, at least the policy doesn't require it. This is more a matter of policy than law as far as I recall. I do not remember there being an exact regulation on this, but this policy was changed by Bill Yates the day he retired, and that was December 31st, 2004, and he gave us a New Year gift on January 1st, 2005, saying you no longer have to be on H1 to get an extension.
Oh, okay. That's good to know.
Okay. Anything else?
Wonderful. Thank you so much, sir. I appreciate your help and advice.
You're welcome. Good luck.
Thank you.
Bye. Okay, Arvind says, I was out of the US, there was a deportation proceeding, erroneously started, and actually you were outside USA already, so the proceeding was terminated. Now the question is, if USCIS ever found out, can they put me in deportation? See, first of all, if the government puts you in deportation based upon erroneous information, that should cause you no harm. Secondly, when they approve the green card, they go over your file. They have all this information. If they approve the green card despite this information, that means it should not become a problem. Of course, they make mistakes, but normally, when you have a situation like this, they have looked at your file. I wouldn't worry about it. Unless there was a real ground for the deportation and they did not discover it, then you need to get a consultation. But if it was a groundless deportation, it was dismissed, terminated, I don't think you have anything to worry about. *5 if you have a follow-up question. *5. Okay. Radha, my perm is approved. We are waiting for the hard copy to file I-140. I've got a BCom degree. Now, I looked at this. I didn't have a lot of time to read the questions today, but I did look at this one. This is a very risky strategy in my mind. Look, there is no one right way of drafting a perm application. What I draft could be done something differently or done differently by another lawyer. I find this to be a very risky strategy where, because of a 3-year degree, your lawyer has to rely upon any equivalent combination of education, training, and or experience. I think it's a very risky strategy. Can it work? It might. Is that the right thing to do? In my opinion, no. Because if the government wants, they can require evidence of why this is considered to be equivalent. Why is this equivalent? Because look at their main requirements. Bachelor's degree or foreign equivalent in computer science, electrical engineering, computer information systems, software engineering, followed by 5 years of progressively responsible experience. It's a really, really oddly drafted labor certification. It beats the heck out of me why they would do it like this, but obviously they must have a reason. So I don't really know whether you're going to win this case or not. It certainly causes me some concern. It may not get approved. I don't know. USCIS is full of surprises, good and bad. Follow-up question *5, please. Follow-up question *5. Press *5 on your phone. All right. We did this already, the frequently asked question. And then we have Shakira123 says, I'm on H1B, I-140 approved. My brother is also on H1B, I-140 approved. Mom is divorced. So the question is, can we bring her here to live for a long time? We are both here on H1B. And the answer is, well, if you look at the Foreign Affairs Manual under, what is it, visas, I think it's 42 Foreign Affairs Manual. You can Google that. There's actually a provision when you have a family member or somebody close to you. It used to be in the old days gay couples, when they couldn't get married. If one came on H1, they could bring their significant other on a tourist visa and keep extending that while they were still on H1. So instead of H4, they got B2. It's kind of the same for parents. If she's alone and she's by herself, she would like to be with family, chances are tourist visa will be extended. But with the Trump administration, I'm hard put to say this is the most reasonable government, so I don't know what they will do. Technically, they could do it if they wanted to. And we've had many, many cases. It's actually in our frequently asked questions, as well as cases from our files, sample cases from our files, where we were able to bring in a parent or a child who doesn't ordinarily qualify under some other problems or the other. We had one child who was undergoing green card, but they had aged out, something happened. So we were able to get them on a B2 and keep extending that. Okay. Now, the port of entry, it's very difficult for me to say how that works out, because the cases that we did, all of them were already here. And they had entered as a regular visitor. They were going to go back. Every case that I can remember, whatever number, I think it was almost 6 or 7 cases in the last couple of years, or maybe a little bit more than that, 3-4 years. Every person who came, they were here already. They had come in with a return ticket, and then their children or their, I shouldn't call them children, they're adult, but their, I guess children is the best word to use. They contacted us and said, what can we do for our family, our parents? And we were able to keep extending that for several years until they decided to do something. For example, one of them became a US citizen. Okay. And then we were able to convert that to a green card. *5 if you have a follow-up question. Puneet Agarwal. Puneetji, you have an issue. I see you are on the phone. When you have been outside USA continuously for 5 years, you've lost your green card. You cannot get it back. There is a procedure for it called SB1, S as in Sam, B as in boy, or also called returning resident permit, where you go to the consulate and establish why you, despite your best intentions, could not come back. Typical examples are somebody got into a very big disease situation. I had a case where husband and wife, one had a heart attack, wife had cancer. So they were stuck in India for like 4 years, and we were able to get their green card back. But the consulate pretty much wants almost a day-to-day explanation for why you did not go back. I don't think that you're going to be able to get your green card back. can you get a visitor's visa? So what happens is, if you Google it, you'll find out that there's a procedure for you to surrender your green card. If you surrender your green card, you can try applying for a tourist visa. Will you get it? I do not know. Consulates usually should be benevolent, and they should look favorably upon the fact that you've surrendered your green card, thereby establishing your intention not to live in the USA. But I have known consular officers to say, well, you had a green card, maybe you want to go and become illegal. Kind of a dumb way to do it. So they deny the B2 on those bases. But consulates can go either way. I can't guarantee that you will get it. But the green card is already gone, might as well surrender it. *5 if you have a follow-up question. Puneet? *5. Press *5 on your phone. Yes, sir. Go ahead, please.
Yeah. Thank you so much for your answer. How can I surrender it while I'm here in India, and then I can go ahead and try to get a visitor's visa?
Yeah, that's the procedure. So basically you surrender it. Okay. And I know that some people have actually surrendered and applied for a tourist visa almost at the same time. You can check with the consulate what their local procedure is. Some people have done it by mail. Some people have gone in physically, filled out the form, surrendered the green card, and then applied for a tourist visa. So there are many permutation combinations, but the essence is surrender green card, apply.
Okay. So in your opinion, I mean, as per your recommendation, this route is much better than the getting an SB1, correct?
Unless you have a really good reason. I mean, I don't know what the reason for staying away for 5 years was.
Right.
I think it's doubtful. SB1 is not normally given.
Okay. All right. Thank you so much.
You're welcome. Good luck, sir. Okay, so from Rugelmon, I'm on H1B, expires on October 2018, spouse is on TN, good till 2020. Now, this case is very messed up, very odd. You went for H1B premium processing and for H4 EAD. They gave her the EAD now, but her H4 begins in October, which is very odd. I think she should not use this EAD. I think your lawyers need to get on the phone with the government and ask them what the heck are they doing. Because if this EAD is approved by mistake, in error, she shouldn't be. She should not use it. If her H4 is approved effective October, naturally she still has TN. She should be able to use her TN. But this needs to be resolved. Okay. I wouldn't use that EAD if I were you. So if she's not on H4 and the EAD is mistaken, definitely she's on TN. If your spouse wants to change her job today, obviously she's a Canadian citizen, she can just go to the airport, or a Mexican citizen. She can just go to the border and get a TN and come back again. That puts her back in TN. Only problem is she loses her EAD then. Okay, and that EAD appears to be mistakenly granted anyway. So I think you have a tough call to make here. Only thing I would do is I would get in touch with the customer service, see if I can open up a request with them, talk with somebody higher up, talk with somebody in adjudications, explain the problem, and get them to tell us that, well, that EAD is mistakenly issued. In my view, she's still on TN because she didn't get her change of status effective until October. So she should still be working on her TN. *5 if you have a follow-up question. *5. Okay. Massachusetts, go ahead, please. Massachusetts.
Yeah, I just spoke to my lawyers, and they said with the approved H4, if we pass the border and come back with a stamp on H4, since my spouse is a Canadian. She doesn't require H4 visa stamp. That's what I heard. So is that something valid?
Hang on. I think we have a problem. First of all, no, I think we have a problem. Hello? Can you hear me?
Yeah, go ahead.
Yeah. I think we have a problem because obviously they have issued her the EAD without converting her to H status right now. Okay? So that EAD shouldn't be used. Now the question is, the fact that the EAD was mistakenly issued, does that cured by her going to the airport or to the border and getting an H4 visa? I don't think so. I think if the document is mistakenly issued, going to the airport and coming in with an H4 does not cure that problem.
Okay. Sir, one quick question actually, just out of curiosity. Does Canadians require a H4 visa?
They don't.
Or just the border?
They don't. A Canadian citizen cannot get a visa even if they want to. There are only two visas Canadians are required to get, E2 visa and K1 visa, or K3, K1, K3. So all other visas are unavailable to the Canadians. They just go to the border and come in. L1, H1, H4, L2, everything else, no visa.
Okay.
All right.
So one option is like, no, I can call the USCIS
to
and
get
ask them.
get in touch with them, preferably your lawyers, and figure out what's going on.
Okay, sir. Thank you so much.
Good luck.
Thank you.
Okay, so the next question is, Sarah, 24, had an approved tourist visa, and there appears to be a misrepresentation in that she said, I'm coming to visit a friend, but she then married him. So one of the key things is, if you were entering USA, not yet decided to marry and changed your mind after you entered, you're okay. But if you came with a preconceived intention to get married, actually, you know what? Let me rephrase that. Government used to say that getting married if you are going back is not a problem. Yeah, this is definitely a little bit of a suspect situation. Then you converted to an H1B, you got married, converted to H1B, didn't go outside USA till you got your green card in 2010. Then you relocated outside, came back in 2012. You also have a Class C misdemeanor. Expungement doesn't help you. Just because a case was expunged doesn't mean that it doesn't have immigration consequences. I plan to now apply for citizenship. I'm eligible to apply both under 3-year and 5-year criteria. I definitely think you need to get a lawyer, ma'am. You have a situation in which there is something in your background that makes me wonder whether there's a misrepresentation, because that's a permanent bar. If you have a misrepresentation or attempted misrepresentation, I should actually rephrase that, a misrepresentation to procure an immigration benefit or attempt to procure an immigration benefit, you have a permanent bar from entering the USA. So I'm concerned about that part. Somebody should sit with you and go over your information in detail, preferably somebody local who can go with you for an interview if necessary. If you consult with us, we can certainly advise you about your situation, but we cannot go with you to the interview if there is one. So you may want to think about that, but you should not do this alone. There's some area here for concern. *5 if you have a follow-up question. *5. All right. Next question is from Akash 989. Question number 1. December 2016, I entered the USA with an L2 EAD. I've been working on L2 EAD on and off from 2017. I even have an H1B stamped and approved from another consultancy with I-797 before I enter into USA. Now I would like to work for company B. Yeah, they can do an L2 to H1B transfer. I don't see why not. You don't have to have worked for them. As long as they did not revoke your H1 before October 1st of the fiscal year in which you were approved, I don't see any problem. You don't need pay stubs. Yeah, they should be able to do that. Can company B transfer my H1B? Yes, I believe so, sir. I don't see any issue. Then your wife is on L1A with company D. D company, huh? I heard that name before. D company. Okay, my L1A is on, my wife is on L1A with company D. We filed an amendment from location Missouri to Illinois. Got an RFE. She's in India due to family emergency. So can we simply submit the RFE docs and travel back? She has to go to stamping as her extension is approved till June 2019. It's a very confusing narrative. I'm not sure I understand. Are you on the phone? Press star 5 if you're here. Press star 5. Okay. Yeah, I need more information. Let's hear from you. Okay, so I don't understand. She has an extension pending and she got an RFE. She has an amendment pending. What are we talking about?
Hey, sorry for confusing you. Actually, we recently got extension approved till 2019 June.
Oh, okay. And see, I'm a little surprised. Why do you have to file an amendment for a change of location for L1As? Usually, change of locations, unless she's working at a client site, in which case I can understand. If it's
it's a client change.
Okay. All right, then it makes sense. So the question is, so we have an extension till 2019. Can I just get a visa stamped on that extension and come back? And my answer would be no, because she's not going to go work at that job site. I think she needs to wait till this case is decided and then go get her extension stamp. Now, if she's going to go back and work at the original site when she comes in, I think she can go get her extension visa stamped. So the key here is whether or not she's going to enter USA and work at the old site, company D.
No, I think I'm confusing. Probably I'm confusing you. Like Rajiv, like we have got extension approved very recently, 7 months ago. Okay, and after that we had applied for the amendment because there is a change in client and location has happened.
I got that. I'm not confused. No, I got that part. Yeah, sure.
So now my wife went to India because of family emergency.
Hang on. Listen to me. Let me make it simpler for you. You've got an extension for location X. She's moved to location Y. She's got an RFE on the change of location. She's in India. Can she enter USA with an extension for location X? The answer is no, I don't think so, because she's not going to work at location X.
Okay.
I understood what you said.
So you mean to say until RFE is approved, she cannot come back?
That's what I think. Now, if the location X job was still open, no problem. Go get your stamp and come in, start working at location X. As and when the amendment gets approved, start working at location Y.
Okay.
Okay?
Yeah. Okay. Thank you.
You're welcome, sir. Good luck. But this is hard for me to, I don't know if I'm right, but I think knowing the law as I do, that would be my best educated opinion. Maybe a guess more than an opinion. Okay, our last question for the day is, let us see. N. Gokhna says, my H1B 6 years will end on December 2018. I have an I-140 approved with current employer. I'm planning to start my H1 extension. I'll be doing it in premium processing. If vendor gets changed after I apply, will this cause me a problem? Client and employer will be the same. So the answer here is depends upon how the USCIS views this situation and how aggressive you want to be. The regulations say only this. If there is any substantial change in the working conditions, you must file an amendment. When the end client is the same, the job description is the same, everything is the same, the only thing that is changing is a middle vendor, is that a substantial change? I'm not sure I can answer that question in a yes or no. I would say, how aggressive do you want to be? If you want to be aggressive, I think you have a very good argument. It's the same job. Why should I file an amendment? But if you want to be conservative, you could say, well, there is a new contract in between these series of contracts. Maybe the government should look at it, make sure there is no substantial change. So either approach, I think, can be argued for. So it all depends upon how aggressive you want to be. *5 if you are here. *5 if you have follow-up question. Okay, we are done with the questions that were listed for today. If you have any question, please press *5. We've got about 10-15 minutes. *5 if you have any follow-up question on any issue. Actually, not just follow-up, any question at all. Okay, we have only one question. Let's go with California. Yes, go ahead, California.
Rajiv, this is Akash, the last but one question.
Yeah, I got it.
Are you hearing me?
One second.
Yeah.
Yeah, we just talked about your issue. Yeah, go ahead.
Yeah. So my wife is on L1. She's in India now. I'm in US.
Don't repeat.
Still, she's remote.
Don't repeat. I just read your facts. I know what's going on. Just tell me what's the question.
Yeah. No, I'm not repeating. What she's working remotely to the client, and her pay stubs are still on.
That doesn't change anything.
How long I can stay in US?
Oh, that's a very, very interesting question. So the question is, I'm on L2, spouse is on L1, she's not here, she's in India, how long can I stay? And the answer is, I have seen this question brought up in some of the discussions with the government, and the government has said, well, we don't consider you to be in status if your primary is not here. So if I would say maybe a few weeks is okay, but you cannot have an extended stay in the United States if the primary is outside the USA. There is no hard and fast rule on this, though.
Okay.
I can't give you a
actually, I'm doing change of status, so
well,
I
then
can.
there is no problem.
Change of status.
Then there is no problem. As soon as you file a change of status, you are in authorized period of stay. I don't see any issue there. Okay.
Yeah, thank you. So ideally, you mean to say a couple of weeks or 3-4 weeks is fine?
I would say even a month and a half probably is okay, but that's a guess. Like I said, there is no exact period I can give you beyond which you become illegal or objectionable to the government.
Great. Thank you very much.
Oh, you're welcome. Good luck. All right.
Thank you, guys.
You're very welcome. All right, folks, I think we're done for the day, and it's always a great delight to be with you. Oh, there's one more question. Oh, it's Marilyn. Okay, Marilyn, go ahead.
Yeah, so this is again with reference to our discussion regarding question that if we can file an extension on the approved of I-140 after 6 years from India. So you said that the last when we approved it in the last 6 years. Just want to clarify this statement one more time. So when you say the H1B is approved in the last 6 years, it means the last approval, because my H1B has been approved multiple times in the extension. So you are talking about the last H1B extension approval.
Hang on. Last means most recent.
Most recent means the most recent H1B extension approval is as long as in the last 6 years, we can get an extension from India on the approved I-140.
Exactly. Okay.
With any company.
With any company.
Okay. Thank you very much.
Good luck. I know law can be very confusing. Okay, folks. As I was saying, good to talk with all of you. We'll see you again in 2 weeks. Thank you for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.